Okay, so I got so many questions about just what the probate process is and how to avoid it. So let's get to it. When I talk about how to avoid the probate process, when I'm advising my clients on what they need when they do an estate plan, the first thing we got to talk about is, what does that mean? What is probate? So many times, if you're talking to an attorney, you're going to hear us say things like, well, this is how you avoid probate. What that means is keeping your family out of court. But you need to understand what probate is in the first place. So, first and foremost, let's understand what a probate asset is. Typically, in any state, when you're dealing with probate court, now that court can be called a number of things depending on what state you're in, but if someone passes away and they leave assets where there are no beneficiaries, and those assets can only be distributed by a court, you have to go through a probate process. But everybody doesn't have to do this. And that's the thing. There's so many things that you can do that doesn't cost money, you don't need a lawyer for, that can allow you to avoid the probate process. One of the things that you can do that is the easiest thing for you to do is, first of all, list your assets out. Do you know what you have? I cannot tell you how many families come to me when their loved ones have passed away and they don't have a clue what they have, right? Mom passed away. She didn't tell me a whole lot about her bank accounts. She just told me that it was at this particular bank, but I don't know anything about her retirement accounts. I don't know anything about what assets she's accumulated. How many of you have had family members that say, we don't talk about money? Be discreet when it comes to your money. Well, that is the opposite of the truth. As a probate lawyer, you are doing your family a disservice and you're going to cost them thousands of dollars later, because guess what? Your assets aren't in some magic vault so that when you pass away, we're going to know we are not superhuman. I tell people that all the time. I am not a private investigator. I only know what you have allowed us to know. So first and foremost, stop being so discreet about what you have. Now, I'm not telling you to tell your business to everybody, but what I am saying is talk to people who you trust and let someone know what you have. Now, I created a Plan Like a King and a Plan Like a Queen toolkit, and that was not really for the world. I created that toolkit for myself because I asked myself one day, if something happened to you, would your family know where to start? And I operate a business. I got children, they wouldn't have a clue. So what I had to do was I had to create this system where I put my assets in one place. And that's what you need to do. First of all, know what you have. Put all of your accounts down, bank accounts, retirement accounts. So if you have a 401k plan with your job, some of you have life insurance policies that come with your job, and you may not even know that they exist. You may have signed something 20 years ago on the job when you first started and not even have a clue who you've named as beneficiary. That's why you have to first start with creating a list of your assets. So once you have created the list of what you have, then on that same sheet, you need to put down who your beneficiaries are. Now, here's the easy part. If you don't know the answer, that means you either A, don't have a beneficiary, or B, you probably named someone years ago who maybe you don't want to be your beneficiary anymore. Okay, so you need to make sure that you know what you've done so far, especially those of you who have been on the same job forever. If you've been on that job for 20 years, it might have been that when you first got that job and you filled out that beneficiary form, you might have named your parents as your beneficiaries. That might have been before you got married, before you were in a relationship, before you had children. Well, fast forward 20 years later, you might want to make a change. So if you don't know who your beneficiaries are, then first and foremost, let's make sure you write everything down and you go to each company, each entity where your assets are, and you designate a beneficiary. If you designate a beneficiary on your account, then by definition, that asset is not a probate asset. That means a probate court does not have to deal with it because you've already told the world who you want to inherit your money. Now, because I've seen the worst case scenarios, I spend a lot of my time in court. What I also know is just naming a primary beneficiary is not enough. Not only do you need a primary beneficiary, but you also need what we call a contingent beneficiary. A contingent beneficiary is a plan B. Okay, so if you name someone as your beneficiary on an account and that person should pass away, you've got to have a plan B, because if you don't, that asset, which by definition is not a probate asset, can now be converted to a probate asset. Okay, so if you are taking notes, and I hope that you are, please write down number 1 tomorrow. Check on who your beneficiaries are, and if you don't know who they are, designate them. And designate a plan A, which is a primary beneficiary, and a plan B, a contingent beneficiary. Now, let's go back to the probate problem. What is it? A probate problem is when you do nothing. And I think that that's where you should start. That's where I start when I'm in the office with my clients and we're discussing an estate plan. I start with, well, what happens if you do nothing? Does anyone know where your assets are? Does anyone know what you have? Do you have beneficiaries designated? Or are you going to leave your family in limbo? And are they going to have to pay me or some other probate lawyer thousands of dollars to figure it out? And even then, when they're spending those thousands of dollars, they still may not find out. I have so many families that knew that mama had an account with so-and-so bank, but I can't find the information. Or I knew that my mom had this particular life insurance policy, but I can't figure out where it is, who it's with, because they never talked about it. So we're going to change that. We're going to have a discussion with the people we care about the assets that we have, because if we don't have a discussion, then that means, guess what? They're going to pay a lot of money later. So you can save yourself some time and save your family some grief by doing it now. We are going to avoid the probate problem. Let's talk about what the problem looks like, though. So let's say you do nothing and your family goes to probate. In most states, when you open up an estate, you have to do a number of things. There are responsibilities. First and foremost, someone has to be designated as the administrator of that estate. Now, that can be someone who is an heir, so a next of kin. That could also be someone who is designated as an executor in your will if you have one. But also in most states, there are some rules on who that person can be. In Tennessee, that person cannot be a felon. That person also might have to qualify for a bond. And a bond is an insurance policy that basically is required in probate court for anyone who is managing money. If you are managing money and appointed by a judge, they want to make sure that you can qualify for this bond, because if you mismanage the money in any way, the insurance company can put it back. You know what that means? That means that person has to get a credit check. Yeah, so you can name your child, and your child may not pass that credit check and they can't be over your estate. So these are things that no one talks about, but these are complications that happen early on that can absolutely be avoided if you have an estate plan. Because if you actually have a will or a trust and you designate individuals to take care of your business, then you actually can designate them and you can waive that requirement that they don't have to post a bond. They don't have to go through that process. But if you don't do that, then the court is going to require it. So now you are creating yet another expense that your family has to pay. All right, the probate problem. The other thing that has to happen is creditors have to be notified. Yep, credit card debt, any other unsecured debt, all of your creditors have to be notified, and most likely they have to be paid first. So whatever money you've accumulated that are in your bank account right now, that money's in your bank account and you're the only person on your account and you don't have a beneficiary, your creditor is going to get it first. And then maybe if there's something left over, your family could get it. That is what happens when you open up an estate, when you have to go through the probate process. Those of you who might be subjected to TennCare, what we call TennCare Medicaid. So that means if you have to go in a nursing home or if you receive in-home health care in your home because you are disabled and the government helps pay for that. If that happens and that's you or your loved one, if an estate is open, in Tennessee, you can't even close the estate until you first give notice to Medicaid that the estate is open, because guess what? They're entitled to reimbursement. Yeah, so we've got credit cards, we've got other creditors that get paid first. Now we've got the government that gets paid first. If just maybe there's something left over, then at that point, your loved ones can receive the assets, but not before paying me, and not before paying court costs, and not before spending months, sometimes years, to get things settled. That is what we call the probate process. So now that you've learned what the probate process is, you've got to understand how to make sure that your family is not a part of it. So we've already talked about what a typical probate asset is, which is a bank account or retirement account or any account where you can designate a beneficiary and you don't. But let's talk about the other part of that. If you have minor children that you want to provide for, if you have young children, they're under 18, or they're at an age where you just know that they're not responsible enough, they're not ready yet to manage their money, and you name them as a beneficiary, guess what that means? That means that if they're over 18 but they're irresponsible, the law says they're an adult. Now, you and I may agree that an adult might not be 18. Even if the law says it, maybe that doesn't mean they're ready to manage hundreds of thousands of dollars, right? But the law says that they can. So if you designate someone as a beneficiary that's at least 18, they're going to get the money in their hand. And what do you think that an 18-year-old would do with $100,000 or more? All right, I'm going to tell you what they're going to do. They're going to spend it. And next month, there will be nothing. I've seen it over and over again. So if you are wanting to provide for someone who you know is not ready to manage money on their own, then that's when you need to take the extra step and actually talk to a lawyer about doing some trust planning, because a trust allows you to manage from the grave. It allows you to put some stipulations in there that says, hey, I know that you are an adult, but I don't think you're ready yet. And I don't think you'll be ready until maybe you've gone to college, or you've gotten a trade, or you've started a business, or you've generated some money. Maybe you've done some things in life first before you're ready for this money. That's what a trust allows you to do. A trust allows you to name a trustee, someone who you believe can handle this job to manage funds. Let's say you know someone who can serve as your trustee, but you're not quite sure that they're the best person for the job. Or let's say you don't know anybody that you trust with your money, and that's okay too. There are actual professional trustees out here that's actually their job. They are bonded. They have the experience. They have the training to manage your money. And I know some of you are probably saying, yeah, but they cost money. Yeah, they do, but they're not going to cost as much money as the person that you name that's not ready for it. Because if you name someone that's not ready to manage money, chances are they're not going to do it right. And they're going to cost you more money than save you money. And it may be, in your case, it may make more sense to just hire a professional trustee. All right. So we're going to make sure that when you name someone as a beneficiary on these accounts, I know we're wanting to avoid probate, but let's not just name people that we know is not ready to manage their affairs. So the other issue that I see all the time is with families that have young kids, families that have children who are under the age of 18. By law, you cannot name them as beneficiary, but nobody tells you that. Okay. So if you go to the bank and you fill out a signature card and they say you put your beneficiaries right here on this page, or if you go online and you designate your beneficiary there, nobody's going to tell you they have to be at least 18. They're going to let you name whoever you want to, because that's not their job to manage. So many times I am in court with families where their children have been named as beneficiaries, but the law specifically says that children are not able legally to manage money. So if you name a minor child as a beneficiary, then congratulations, you have guaranteed that your family is going to go through the probate process. All right, thank you. And if you have questions, let me know, because here's the thing. My whole goal here is to make sure that you understand the probate process. I have had so many questions that I think the best way to answer them is if you ask them right now, chances are somebody else is thinking the same thing. So let's have a chat. Let's avoid probate by understanding how to get there. So we're not going to name a minor child because the law says they can't manage money. And then the other part of that problem is, let's say you name a grandchild or niece. If you name that child and they're under 18 at your death, then it's just not an automatic, oh, it goes to their parents for their parents to manage. That's not how the law works. The law says somebody has to be appointed by the court in order to manage this money. Now, the somebody might be the parent of that child, but not if they don't qualify for a bond first. Not if they're not credit worthy, not if they are a felon. In our state, you can't do that. And in most states, there are qualifications that they have to follow first. It doesn't matter if they're the parent. So there are many situations where the parent cannot manage their child's money. And quite honestly, they probably shouldn't. That's a recommendation that I tell most of my clients. If you want to leave money for your grandchildren, it might not be a good idea to name their parents over that money, because that parent might be tempted to utilize that money along the way for anything, as opposed to it being a hand up as opposed to a hand out to your grandchildren or your great nieces or whomever. All right. So if you want to provide for a minor child, then you need to consider trust planning. Now, I'm going to talk about that later. Not today, but I am going to do a live about trust because it's a whole thing, but I need a lot more time to talk about that. Today, I want you to know that you need one first. All right. So now let's talk about a will and what it really does for us and why it still is important though. Trusts are my favorite thing, but everybody needs a will. Everybody. But the biggest misconception that I have seen concerning a will is that because you have a will, you avoid probate, and that is not true. The purpose of a will is to tell the world what to do just in case you don't do all the things that I just taught you to do. So let's say you have this old credit union account that you opened up maybe when you first graduated from high school. You know, maybe it's not a lot of money in there. You don't use it anymore, but you forgot about it. And there's no beneficiary because nobody told you to name one, right? If that one account ends up being the account that ends up in probate court, then your will is important because your will tells the world what to do with the accounts when I haven't told the world who my beneficiaries are. So we need them, but they don't fix the whole problem, right? They're only there in case you don't do your full planning or life happens and perhaps you don't have an opportunity to make changes like you want them to be made. For example, if you have a beneficiary on an account that passes away and you haven't had the time to go and make those changes, then your will tell the world what to do. But not just any will, not your Google wills, but a will done by a lawyer and an estate planning lawyer. So even if you have a family lawyer that helps you with your tickets and helps you if you have to go to jail or helps you with whatever, that doesn't mean that's the lawyer to draft your will, guys, okay? I tell people all the time, if they call me and say, I need someone to get me out of jail, I say, do you have a pen? Let me give you a number because that's not my thing. Go to the lawyer that actually does this work, that is trained in this work, that is educated in this work, and that continues to learn estate planning. That's who you want to draft your will, all right? Not the forms online. And I know in 2025, it's very easy to Google this document or use some AI feature and say, hey, draft me a will. Let me tell you something. I have probably made the most money off of those wills. Yeah, that's because families end up hiring me because it's screwed up. It's not right. You cannot rely on a computer and you cannot rely on some other online entity that is not a lawyer that understands your life to draft a will. All right. And so, I got a question here and let me answer this real quick. The question is, how long does probate take? And that depends. That's a really good question. In different states, it's different responsibilities. But in most states, that process of notifying creditors and notifying the government that a person has passed away and also notifying any heirs of that estate, that can last a period of time. Now, I'm in Tennessee. I'm licensed in Tennessee and Texas. In Tennessee specifically, the process has to last at least 4 months. There is a 4-month period where creditors have to file a claim in the estate. You cannot close an estate until that period closes. And so whatever state you're in, I would encourage you to look to find out or to ask an attorney what your creditor's period is, because you can't close an estate until that's done. You have to give the creditors an opportunity to file claims if they're owed money. All right. Also, a probate problem, because that also means that if your family needs to handle your business, perhaps they need to pay for final expenses for you. They need to pay for the funeral. They don't have access to the money. Guess what? they won't have access because the estate has to be open for a period of time. So that also creates a little bit of an issue as well. So getting back to your will though, you want to make sure that you have one, but it doesn't solve the entire problem. And you want to make sure that it's done by a lawyer, because there are very strict requirements in every state on what makes a will valid. Just because you have a document and you call it a will does not make it a legal will. A judge actually has to look at that document, determine that it meets the strict requirements of the law, and then admit that will into probate. That is at that point when a court respects a will. Okay, so many people I've met over the years will take a will and just go straight to the bank and say, hey, here's a death certificate to show you that my loved one passed away. Here's the will saying that the money goes to me. And the bank is going to look at them and say, okay, thanks for showing me this document. Come back with a court order. Because just showing them a document that's called a will doesn't make it valid. A judge has to say it's valid, and not until the judge says it's valid will a bank or any entity respect the fact that you've been named in that document. Until a court order is issued saying this will is valid, it means nothing. It means nothing to any entity. All right. So what is a full estate planning process? I've talked about a will. I've touched a little bit on the trust, but there's more to an estate plan. The estate planning process in and of itself is really the process of planning for the inevitable. It's planning for the moment when you have passed away, or if you are incapacitated and you are unable to handle your affairs. Estate planning is for everybody, because every one of us will experience death at some level. Every one of us will know someone who has experienced death at some point. And a lot of us have loved ones who have experienced being incapacitated, being disabled, unable to take care of themselves, and needing someone to do that. I have so many clients who are spouses and literally have to hire me to go to court, to be appointed by a judge just to take care of their husband or their wife or their loved one who they've been with for 20 years because there's no estate plan. So not just having a will is that's one piece of the puzzle, but that doesn't complete your puzzle. You need to also think about incapacity. What happens if, God forbid, you get in a wreck and you're unable to speak for yourself? Do you have the people in place that can make decisions for you? Have you talked to your people about what decisions you want them to make? Because if you've not talked to them about the decisions that you want them to make, then guess what? Nobody knows what you want. And I've been in court with a lot of fights. And let me tell you, I've been in court with family members fighting about whether or not mom wanted to be cremated. I've been in court fighting about whether or not mom wanted somebody to have silverware or big screen TV from the 90s or whatever, because nobody talked about it. You can solve so many problems by just simply having a conversation with your family and saying, this is what I want. I'm also going to get it in writing, right? Because just talking is not enough, but having the conversation is helpful. So a healthcare and a financial power of attorney is always a part of the estate plan. For my clients, it is required. I don't want a single client that is willing to do a piece of the puzzle. All of my clients have to be willing to be protected from A to Z. So not just having a will, but actually looking into what happens if you're incapacitated and making sure that the right people are in place. Because without a power of attorney, then actually if you became incapacitated and there's no power of attorney in place, your family will have to petition a court to appoint you. I will tell you one of the craziest problems that a lot of my clients have, which is the fact that they own a house, probably with their spouse, and their utility bill is only in their spouse's name. Anybody experience that where, you move into the house and, your spouse says, I'll go ahead and set up the utility account. Okay, cool. No problem. Well, then spouse gets disabled, can no longer speak for themselves, can no longer handle their affairs. Guess what? If you call the utility company and say, I want to pay my bill. Oh, I'm sorry, but that bill is in so-and-so's name. Are you their power of attorney? Do you have anything to show that you've been appointed by the court? Those are the questions that are going to be asked by that utility company, simply because there is no power of attorney. So the basic plan is going to be a will, a power of attorney, healthcare, and financial power of attorney. And for those of you that want to provide for young loved ones, then you need to consider a trust. I'll check you on my next live. We'll talk more about the trust. See you soon.